like we have a few more people coming in. Thank you. All right. So welcome everyone. My name is Angela Merkins and welcome to the Rec Innovation Labs workshop with New Media Rights with Erika Lee and Katie Henry. Thank you, Erika. Woohoo! I don't know if you can hear that in the background. Welcome. Erika Lee's been one of our mentors here at the Rec for several years. Thank you so much for all that you do for our students. And she is an attorney with New Media Rights and has amazing educational information for us regarding startups and legal considerations. So thank you so much. I'm going to hand it over to Erika.
Perfect. Thank you for the introduction. We're really happy to be here. Sorry we're not there in person, but it's probably for the best because I am actually getting over a cold, so I won't be getting anybody sick today. But yeah, so today, and I have with me Katie Henry here, who's one of our amazing law students at California Western and who's also in the clinic. And, today we are going to be talking about some basic legal considerations that y'all should be thinking about in kind of the early stages. So see if I can get the PowerPoint going. There we go. Okay, so a little bit about New Media Rights and what we do for those of you who haven't heard of us, right? There are three big things that we do, but first and foremost, we are a clinical program of California Western School of Law. So we're located down here in downtown San Diego. And there are three things that we do. We provide free and reduced fee legal services. We also provide educational videos and guides, and then we also engage in some public policy work as well. So I would say that the bread and butter of what we do is provide those free and low cost services. And here's some examples of the types of things that we've worked on before. We're known for preventing and helping triage copyright and trademark issues. So that might be questions about ownership and licensing, right? Are you actually the owner of the work that you've created? Or maybe is someone else? Can you even move forward with your project? Or do we need to resolve some sort of ownership issues before we can really move forward? We're also very well known for our work assisting with and defending against DMCA takedowns. So, that's something that we're known for. What is the DMCA? That stands for the Digital Millennium Copyright Act. And within that section of copyright law, there are some tools available to copyright owners to be able to send takedown notices to different websites, right, to get their content removed from that site. And so obviously, as you can imagine, there are probably some legitimate uses of third-party content that kind of get swept up in those takedowns. And so we're known for our work in defending against those takedowns that seem to be a little bit overreaching, right? But, we can also assist on like a rights enforcement side as well, right? If someone's having some copyright infringement issues, we can provide some guidance there. I see a question in the chat. Do you do patents? That is actually one thing that we do not do. We are not barred under the patent bar. However, if you are interested in patent assistance, that is something, please feel free to reach out to us because we have resources that we can direct you to different folks in our local community here in San Diego. So great question. And then we can also, assist with things like cease and desist letters or demand letters. And I think the key thing to remember about those is if you ever get a cease and desist or a nasty lawyer letter, do not ignore it, right? Immediately contact an attorney, even if you think it might be nonsense. There's usually like a deadline for some of the demands in those letters. And so even if the ultimate game plan is, hey, we're not going to be meeting these demands, you don't want to just like blatantly ignore those things. Sometimes those are kind of scare tactics, but not always, right? So please don't ignore those. And then another thing that we can assist with is contract review and drafting. Now the caveat here is they have to be kind of California-based contracts. We're only licensed in the state of California. And so if you have a contract that's kind of based in the laws of another state or another country, we may not be able to review it or review it completely, right? We may only be able to give some like limited advice there. So if you've been presented with a contract, or maybe you need a contract drafted, that's a good time to reach out to us. We've also worked on terms of use and privacy policies, and I believe Katie's actually working on one right now. And so you may have heard different terminologies for these things. You know, they're called terms of use, terms of service, and user license agreements, right? Those are more or less interchangeable. These are important to have in place if you at all have some sort of interactive website, because you want some rules set for everybody who might visit and interact with your service. And then as far as like privacy policies go, those are actually critical in California, really important. You need to be able to tell people, if you're running, again, an interactive website, what kind of data you're collecting from people, how you're collecting that, how you're using it and why you're using it, right? So transparency is key. And there are some pretty aggressive privacy related laws here in the state of California. And so that's not something to sleep on either. And then, you know, similarly, we can kind of provide some guidance on privacy and data issues as well. And then also provide some assistance. We've provided some assistance on some online consumer disputes, right? So if you're selling something on Amazon or Etsy or any type of e-commerce platform and there's some sort of issue that comes up, that's something that we can also provide some assistance with as well. Now, this is not necessarily like an exclusive list of everything that we might do in the clinic. We certainly provide other services that aren't necessarily on this list, but you know, I think it's nice to have kind of an example of some of the things that we do, just so that you get a better idea of some of the things that we might do, particularly for kind of like the startup and technology related projects that you may be working on. Okay, so enough about our services. A couple of resources I have up on screen here if you're interested in learning more about anything that we're going to talk about today. First and foremost is our book, Don't Panic, shameless plug / self-promotion there. It's, you know, a basic legal guide written in plain English, right? So it's a little bit more easy to understand than trying to find information about some of these topics in other places. We also have the Fair Use app. We have a number of different guides on our website. We have a YouTube channel that I think is pretty fun. So you can visit newmediarights.org and find all of those different resources there. So please feel free to explore. All right, so our focus today, we don't have a ton of time, so we're going to focus on some common areas where it's really easy to make mistakes in the early stages. And those are in copyright and contracts. And then we'll leave hopefully a bunch of time near the end for some Q&A. So we can only really talk about big picture and like general concepts here. So if you have a specific legal question about something that you're working on, please go ahead and submit a contact form on our website. I have the link to that up on screen here. That's generally the best way to get in touch with us. And just for confidentiality reasons, right, we can't really answer those specific questions in front of a room full of a bunch of people, right? So best to reach out if you have those specific questions. Okay, so with that, and I'll also be like kind of monitoring the chat. So if any questions come up, please go ahead and use that if you'd like. So the big question that we often hear is, when should I talk to a lawyer? So I've kind of identified a few spots where it might be a good time. So first and foremost, right, I am selling a good or some sort of service. You're going to probably be thinking about things like logos, brand names. Those kind of all fall under this area of trademark law, right? That are it's designed to prevent confusion from consumers in terms of, okay, where is this product coming from? What is the origin or the source of that good, right? So you're going to be thinking about that. You're probably going to be thinking about patents, trade secrets, right? Patents kind of protect those leaps of innovation and inventions, right? Or processes and new systems. Trade secrets are basically anything that derives its value from being kept secret. So what's an example of that? The Coca-Cola recipe, or some market strategies that you might have come up with, even some contact lists that you might have. I love the example someone once gave, this example of the Krabby Patty secret formula for any SpongeBob SquarePants fans out there, right? So those are trade secrets, right? So you might be thinking about that, right? If you, particularly if you are offering some sort of service, right? If you're running an interactive service, what do I mean by that? Well, it means that you're allowing users of your website or users of your service to interact with you or to interact with each other online, right? You should be thinking about certain types of liability for content that those users might post on your site. And this is, again, kind of coming back to the DMCA that I was talking about earlier. Not only are there tools for copyright owners to take down their content from the internet under that law, but there's also some really great protections for service providers, social media sites, to give them some like safe harbor protection if a user goes on their site and posts something that's infringing, right? That way the service won't be held responsible for that infringement under those safe harbor rules, right? And there are certain steps you have to take in order to take advantage of that protection. And so that's something that you might want to talk to a lawyer about. And then also, depending on what you're doing, there might be some specific laws that affect your business in particular. So if you're doing anything in healthcare or with the environment or food, right? Those have pretty particular areas of the law that are special to those industries. Okay, so another time where it might be prudent to start talking to a lawyer would be, well, I want to work with somebody. I want to hire a team, or maybe just one contractor, or maybe I want to hire another entity to help me do something very specific. That's a really good time to talk to a lawyer too, because there's always going to be questions of like, all right, who owns what in this relationship? Who is going to own this either content or product that maybe this third party is helping you create? What kind of contracts do we need to have in place to make sure that this relationship is legitimized, right? You also probably, and I don't have it on this slide here, you're probably starting to think about like employment concerns too at that point if you're trying to hire someone to work with you. In California, it's actually a lot more difficult than it used to be to hire independent contractors, um, particularly if you expect them to do like the work of your business, right? California really wants everybody to be hired as employees when they're working for somebody. So that's a really good moment when you want to hire somebody to go and talk to a lawyer to make sure that you're not running afoul of any sort of employment laws, right? And then the third point up on screen here is I'm starting my own web service or my own app, right? And again, kind of circling back to the terms of use and privacy policy. Those are pretty essential, right? You might also, again, be thinking about the DMCA, the CDA, or other ways to reduce risk. The CDA actually, that stands for the Communications Decency Act. It does a lot of things, but importantly, it prevents lawsuits against service providers online based on what their users are saying, right? What their users are posting and doing, right? So I think these are kind of three good touch points for when it might be a good time to go and talk to a lawyer. And if you forget everything that I just rambled on about and it only come away with one point on this slide, is that you should talk to a lawyer early, but at the very least, before you start to invest resources and time and energy into launching your product or your service, or before you want to work with somebody else, right? Early is better. Okay, so now I'm going to hand it off to Katie, who is going to introduce us to some copyright concepts.
Hi, everyone. I'm Katie. I'm one of the student fellows here with New Media Rights. Just want to thank you guys for joining us today on Zoom. So I'm just going to jump right into the education. So copyright law protects works of original authorship, which gives that author, that creator, the exclusive right to reproduce and distribute that work or create new works based off of the original work. That's also known as a derivative work. And they also have the exclusive right to publicly perform the work. So that copyright protection, it lasts for the life of the author plus 70 years. Or in the case of a corporation, it will last either 120 years after the creation or 95 years after publication, whichever of the two is sooner. So you're looking at a pretty long protection span for either of those. And then the bar for protection is really low. If the work is fixed in a tangible medium, it can be protected by copyright. So even the appearance of websites or emails can receive copyright protection. So on the next slide here, we have a few examples of original works of authorship that can be protected by copyright law. An important note here is that ideas cannot be protected. So to receive copyright protection, you would need to turn your idea into an actual expression, like by fixing it in that tangible medium, by, writing it in a website, or writing it down in a book, something like that. And then on the next slide here, we have some examples of works that would not receive copyright protection. So like I mentioned, ideas are not protectable by copyright. So for example, the idea of a superhero that flies and has super strength, that's not protectable. But the actual expression of Superman, the cartoon, that is protected by copyright. So then titles and names and short slogans, those are not protected by copyright, but they may be protected by something like trademark. And then processes and systems are not protected by copyright, but could be protected by something like patent. And then also other works in the public domain are also not protected by copyright. We're going to talk about this a little bit more in a second. So let's see. Will you go to the next slide? Sorry.
No worries.
Okay. So, right. So you would have the benefit to, or the ownership, copyright ownership of any original content that you would create. And that copyright protection is automatic, meaning once you create that work or you fix it in a tangible medium, you automatically will own that copyright. And it's important to note that you don't have to register the copyright with the US Copyright Office to gain that protection. On the other hand, registration can be really important if you intend to enforce your rights or claim that ownership. You need to register your copyright with the US Copyright Office, particularly if you are going to sue for copyright infringement. So that's, something to keep in mind there. And then licenses can give you permission to use your copyrighted work without giving up your ownership. So you could tailor licenses to be exclusive or non-exclusive, or transferable or non-transferable to meet your needs depending on what would work for you and your business. So for example, when you upload a video or any particular content to YouTube, you give YouTube a non-exclusive license to use and display that work, but you do not give up your ownership. And then on the other hand, we have assignments, which fully hands over that ownership of your copyright to someone else, another entity permanently. So that's another option there. And then, so one of the most commonly asked questions is, what can I do if I want to use someone else's content? So the short answer is, because you don't have the copyright right to use or distribute someone else's work, you can't. So if you want to use a creative work without potentially violating another person's copyright, you can get a permission by seeking a license. Just, you can ask them directly, or sometimes they post where you can purchase the license. And secondly, you could potentially see if your use qualifies as fair use. This can be kind of tricky, so it would be good to talk to a lawyer before deciding that something is fair use. It's considered a defense to copyright infringement, so not a guarantee. And then thirdly, you can check if the work is going to be in the public domain, meaning the copyright protection term has expired or potentially never existed in the first place. And generally, if you decide to use someone else's content, you're going to need to contact that copyright holder to get a license and directly ask for permission. And the good news is that there is a lot of openly licensed content out there. So creators have made their works available for public use. And when something is openly licensed, it's given a broad license that lets you use and distribute and even sometimes like modify the content without having to reach out for permission. A small caution here, because with open source content, sometimes people can upload things that they actually don't own themselves, and they'll just slap, open source on it. So just double check that source and be skeptical if you're seeing trademark Disney, something like that on it. You know that you can't use that. So just consider that. And another consideration for open source content, if you incorporate a particular section of open source content into content that you've created, you can't claim that particular content is proprietary. So that's just one important note. And then let's see. Okay. So beyond getting a license, there are a couple other ways that you can legally reuse content. So the first is going to be fair use, which I had mentioned briefly. That allows you to use portions of someone else's copyright work without getting permission. So fair use is considered through a 4-factor balancing test. It determines whether a particular use of a copyrighted work can be considered likely to be fair use. Unfortunately, today we're not going to get into the factors. It is pretty detail intensive. If you have a question about whether your use of someone or of another copyrighted work would be considered fair use, feel free to write into our contact form. That's something that we frequently help out with, provide guidance on. And then, so the second way that you can use content without getting a license is by using works in the public domain. So right now, the general rule is anything prior to January 1st, 1930. So the original publication date, if that was prior to January 1st, 1930, it has since passed into the public domain, meaning that copyright protection has expired or potentially, like I said, never applied in the first place. So anything in the public domain is free for public use, whether it's commercial or not. And just a little note here, I think is kind of interesting. Courts have recently upheld that AI generated works are in the public domain because there's no human authorship, there's no human creator. So because the outputs are not protectable, you might want to be cautious about using AI in your projects, because if you intend to claim ownership over that and then it comes out, that that's actually AI, it's possible that your protection never existed. And so if you were hoping to, enforce those IP rights, it could be a potential issue. So just something to keep in mind as all of you guys create. And that's pretty much the gist on copyright protection. So I'm going to hand it back to Erika to talk about contracts.
Yeah, and I think what Katie's saying too about the artificial intelligence is something to keep an eye on, right? Because as Katie said, like right now, those works are not protectable, but that may change depending on the different lawsuits that are currently being fought over in the courts right now. But I think as an additional kind of add-on to that, of course, if you're using AI, we just said those outputs are not protectable, but like if you are iterating on top of that so much that you are coming up with your own like original content and kind of mixing it with that AI output, of course, like your original contributions to your project can receive protection, right? Because as Katie was saying before, there are a few basic elements to receive copyright protection, and in that it has to fit within this category of protectable subject matter, and it has to be fixed in a tangible medium, just like saved or written down somewhere. But then critically, like there has to be some originality, right? That bar, as Katie was saying, was really low. And so courts will recognize that the fact that your original creations that you are iterating on top of this AI generated output will receive some protection. It just gets a little bit messy in terms of how do we enforce that, right? So just, be a little bit cautious with the use of AI. And if you have questions, please feel free to reach out to us or another attorney to kind of walk through what type of risks might be at play. All right, so let's shift focus a little bit to talk about contracts. The first thing to know is that contracts describe a legally enforceable relationship between two people, two entities, a person and an entity, right? And there are two things that aren't immediately apparent to people who haven't necessarily seen the life cycle of a lot of contracts. And those two things are that, number one, just because you have a contract with someone doesn't mean that they're actually going to do what's written in that contract, right? And also, even if you don't have a contract, people might just decide to do exactly what they said they were going to in the first place without issue. So, in other words, things can go really poorly even if you have a contract, and they can go really well without one, right? Those two things can exist at the same time. And realizing this allows you to start to understand that the document itself isn't necessarily magical and it can't force people to do things. But of course, they are legally enforceable. So it's important to always get your agreements in writing and ideally, in a formal contract. Don't just rely on verbal conversations or just email. And I think it's worth spending a moment to talk about email, right? Because email communications are really great for record keeping purposes, but they're not contracts. They're not necessarily going to always be enforceable. Now, in some instances, courts have held that emails can be considered a contractual relationship, but it's a lot harder to argue, right? And the reason for that is, there are three basic elements of an enforceable contract, and those are offer, acceptance, and what's called consideration, which is just a fancy legal term to describe a bargained for exchange of some sort, right? Like I'm paying you $50 to come and mow my lawn, right? That's consideration right there. Now, email causes questions around whether somebody truly accepted the terms of the agreement, right? Because in an email, you can't really like sign your name to an email necessarily, right? The classic form of acceptance is someone signing that agreement, right? So just be cautious about relying on email conversations or verbal conversations, and it's best to get things in writing in a formal contract. Similarly, right, like don't start working on anything for someone else until you have a signed contract, and vice versa. Like don't allow someone else to start working for you without a signed contract if you can, right? And importantly, too, you should avoid what I like to call Frankenstein agreements. What is a Frankenstein agreement? Well, it's basically a contract that you've brought to life by piecing it together yourself, right? By going to Google and searching for something and picking a clause from this agreement, and then finding another one and picking it from that one and throwing it all into one cohesive work. And it can also be just like a wholesale copy of someone else's contract or terms of use or privacy policy. I see this all the time where someone's like, hey, I've got a terms of use and privacy policy. And it's just like from a completely different website that's not related to anything that they're doing. And so it's important to remember that contracts should always be specifically tailored to fit your particular circumstances, right? The facts really do matter, and the context of an agreement can really change what has to go into a contract. And sometimes having some sort of random contract or like a Frankenstein agreement can sometimes be worse than having no contract at all, right? Because it's almost worse to agree to something that you definitely can't do, for example, than to not have an agreement in place at all. Okay, so a lot of contracts are generally presented as this is a take it or leave it situation. But at the very least, you should try to understand what it is that you're signing and how it affects the work that you're currently doing, and maybe like other work that you want to do in the future. And you might be able to negotiate provisions. More often than not, you have a little bit of ability to negotiate things that don't really make sense for you. And it really is worth discussing your contract with a lawyer because they're going to be able to spot red flags that you just can't, right? Because you haven't had the experience or the training to be able to spot those things. And I think, the biggest problem that we see is people rushing into things, right? Rushing into an agreement because they got to get this thing done. And then it comes back to bite them if they haven't taken a moment to consider the situation at hand, to consider the facts and circumstances and account for potential pitfalls that could occur along the way. And this can be really difficult, right? Because as entrepreneurs, right, you want to work really quickly and you want to get things done. But very often lawyers are going to come in and pump the brakes and get you to slow down and consider potential consequences and help you think through certain risks and maybe help you pivot away from doing a certain behavior. So, be prepared to slow down a little bit and pause to think about, what are the risks here? What does each side on this relationship want? What are your deal breakers? How do we build in protections against like worst case scenarios and also protections to protect the best case scenarios, right? Okay. So now I want to talk a little bit about how contracts and copyright interact with each other because they do, right? Contracts can and actually should alter some of our basic copyright ownership rules. So remember that the general rule when it comes to copyright ownership is that whoever creates the content owns the rights to that content. And so we can actually get around this rule by using contracts, right? So there's a very common issue that arises when you want to hire someone to create content for you. So let's take this example of hiring a software developer to help you code certain parts of your new app or your new website. Ideally, contracts to transfer copyright should happen before that person ever starts working. Because we know, right, that basic ownership rule is that whoever creates the content holds an ownership interest in that work. And so without an agreement with that person, then joint ownership arises. What is joint ownership? It's when two or more people get together and they create a work that's protected by copyright. Each of those people owns 100% of the rights. Now, it's a little bit like counterintuitive, like how can two people each own 100%? But that's how it works, right? And it isn't outright a bad thing to have joint ownership in something. However, more often than not, it makes it difficult for a company to be able to exploit that content in the way that they want to. So, and the reason for this is again because joint owners, they can each like exploit the content in the way that they want to, but they have to compensate their joint owner their share of any revenue that might be owned. And so if you don't want to have to keep paying a developer that you hired for like a short-term project forever, then you should probably make sure that they sign some sort of an agreement that is either like a work made for hire or gets them to transfer their copyright ownership before they ever start working for you, right? Okay, so you've now heard me use like a bunch of different terminology: joint ownership, work made for hire, assignment of rights. So what's the difference between all these things? We've talked about joint ownership, two people each own it. Work made for hire, what is that? Maybe you've seen that before. It essentially describes a type of copyrightable work that is not owned by the individual who actually created it. Now, there's a specific rule that you have to follow in order for a work to be owned by somebody other than the creator. So there are two rules here. Number one is that if an employee creates something for their employer and part of their scope of their employment, their job duty was to create that content, then the work is owned by the employer, right? So that's probably the most common way that folks see work made for hire in the wild, right? But another very common way is this other rule, which is these specially commissioned works. And what happens in that instance is that, like, okay, you're hiring a developer, right, to help you code this app. But if you want to own the stuff that that person is creating, but you don't want to hire them as an employee, right, you have to have an agreement in writing that specifically says everything that you create for me is going to be considered a work made for hire. You have to use that exact language, right? And then both of you have to sign it. And this has to happen again before it's ever created, right? Because it envisions this like future work that's going to be created. That's the rule, right? And so it's very easy to make the misstep of not doing that before they start creating something. Now, it's not an unsolvable problem, right? It just means that that person now owns some sort of copyright interest. But you can get that person to transfer their rights, right? By an assignment, permanent transfer of rights. Typically, again, assignments have to happen after that work has been created. But the problem with that, especially in this like situation where you've hired a developer to create something, is that it can be difficult to go back to that person after the work is done and be like, hey, I need you to like assign your rights to this thing that you created for me. Because they're probably going to ask for more money, or they're going to be like, no, right? Why would I do that? This is taking off. This is really cool. Of course I want to be involved, right? So again, still a good idea to kind of do that as early as possible. But there are also like drawbacks to doing something like a work made for hire. For example, it can trigger labor code issues. And essentially, it's a little bit complicated, but if you're hiring that person as an independent contractor, but you have a work made for hire provision in the contract, generally the law will consider that person a statutory employee, which basically means that you still have to like have workers' comp and disability and unemployment insurance for that person as an independent contractor, which is a little funky, right? That's the whole reason you didn't want to hire them as an employee in the first place. But anyways, so my point is that sometimes work made for hire isn't the best language to include in a contract, depending on what you're doing. So again, it's worth discussing this with an attorney, particularly if you're not prepared to like either hire someone as an employee or actually like pay into these statutory employee obligations. Okay. So, and don't forget, licenses are also contracts. So if you are trying to get a license to use something, at the very least, you should know who owns what. Are you promising some sort of company that maybe is hiring you to create something for them? An assignment of all rights? Can you even do that, right? Like, did you use content that you didn't own to begin with? You can't really agree to that transfer then. What kind of representations and warranties are made within those agreements? What are you promising to that other side? Do you make no representations as to what this license material is, or do you make stronger promises? And importantly, right, you need to know who this other party is in any contract, but I think particularly in a license agreement. Are you dealing with a major company? Are they some sort of like indie or startup company? Are they an individual, right? Each of these folks may have different interests and may or may not be open to negotiations, right? So it's worth looking at these things from a big picture perspective. Other ways to like kind of limit your exposure overall, if you're thinking about like what legal issues you might be coming up against in the future. One thing you might do is form a business entity. Business entities can help kind of shield your personal assets from different forms of liability. And there's also tax advantages to doing that. And it can be like a mark of professionalism to have a business entity. There are also, again, like some drawbacks to depending on what type of entity you want to form. Most of them have some sort of maintenance cost, a yearly maintenance cost, upkeep costs, and there are other like formalities and requirements that you have to meet to do that. If you're interested in forming a business entity, that's something that we don't do here at New Media Rights, but again, we have resources and referrals to provide if that's something that you might be interested in. So please feel free to reach out. And then insurance too is another good way to limit your exposure to liability. There's all types of different insurance plans when it comes to like personal injury or bodily harm or property damage. This might be really important if you're doing something with like heavy equipment, or you have a lot of personnel, or you're doing a lot of like activities and events and stuff, right? You might also consider errors and omissions insurance, which is also, you may have heard of this as media peril insurance. And it typically covers things like copyright infringement claims, defamation, other types of errors or oversights or acts of negligence that you might make in the course of creating content, right? Those things can be an important thing to have. While it may not necessarily like make the problem go away and act as like a defense to any sort of legal claim, those policies do help cover the costs of dealing with those claims, right? So that can be really helpful. And I always tell people, like, you can always get a cheap insurance policy, and then at a point where you start to expand, you can kind of up that policy and maybe spend a little bit more money for more coverage, right? But at least having something in place can be a good idea. All right, so what? And I'll use this slide to kind of conclude and then kind of turn it over to any questions that you all might have. What happens when I break copyright law? Why does this even matter? Like, what happens if I don't have a contract or I decide not to follow my contract, right? Well, it could result in things like cease and desist letters, or those angry demand letters that are demanding thousands of dollars from you, or asking you to stop doing something or to do something that you weren't doing, right? Then you have to deal with that. It could result in DMCA takedowns, right? As I kind of referenced earlier, if you all of a sudden are uploading something, or you're using something that you didn't have permission to use, the copyright owner could issue a takedown, and it does then have to come down from whatever website it might be up on. It could result in the termination of social media accounts, like your YouTube accounts or Instagram accounts. And this actually like can be a pretty big consequence for folks who are maybe being like an influencer, quote unquote, or making any sort of like ad revenue online. YouTube has like a 3-strike policy, meaning if you infringe copyright 3 times, well, you're out. They're going to terminate your channel, and you're going to lose all your subscribers, all your view counts, all of the ad revenue that might have been sitting in a pool waiting for you, right? And you can't get that stuff back, or at least you can't get it back easily. So that can have some pretty serious consequences for folks who are making the bulk of their revenue in those ways. And then finally, lawsuits, which do cost a lot of time, money, energy, emotions, right? You want to avoid a lawsuit at all costs, right? They can go on for years and years and years. And so this isn't meant to scare you at all. It's just meant to encourage you to proceed with caution, right? When you're dealing with these things. And when in doubt, don't be afraid to reach out to New Media Rights or to another attorney for assistance to be able to walk you through those issues. So I think with that, I'll leave it open for some questions. Does anyone have questions about what we've talked about, or did it trigger some questions for folks? I do see one question in the chat, wondering whether your organization might be able to help learn about regulations around, manufacturing and safety to know about in regards to children's toys, right? I think there are some things that might fall within our purview there. We have some very limited experience in that particular area. But you know, if for some reason we can't, we can usually direct you to someone who might be able to. So yes, please feel free to write a contact form and we'll see what we can do. Yeah, absolutely. Other questions? Now's your chance. Hi.
Just a really quick one. So if students are interested in reaching out to new media rights, what is the best way or best practice for doing that?
Yes, the best way to do that is to go to our website, and let me put the I have a direct link up on here somewhere at the beginning, and fill out this contact form. So if you go to our website and there's a contact us button there, if you click on that, there's we have a form for a request for legal services. That is the best way to get into our system. That's kind of what we're looking at when we're looking at inquiries, and we do get a lot of inquiries, and so it's really important to go through that form for sure. Great question.
Help to let them know that they are affiliated with the Rec Innovation Lab?
Yes, there is. Yes, absolutely. There's a section in the form that's like, who referred you? And definitely put like the Rec Innovation Lab, because we'll see that and be able to identify that. So yes, great point.
Awesome.
I see another question in the chat here. Do you know how we can do a prototype for our new invention the easiest way? That might be a little bit outside of my purview. Again, some of the questions related to inventions are more focused on patent law. And this also sounds a little bit more technical than what I can answer. But you know, like I said, we have resources if you're interested for patent assistance. Please do feel free to fill out a contact form for those.
Yeah, and if you wanted to sign up for the Rec Innovation Lab, we have a makerspace and 3D printers and a lot of mentors that could help you with prototyping. So, and we also have a couple mentors that are specifically, their area of law is patents. So, feel free to sign up for the Rec.
There you go. Perfect.
So, yes. Thanks.
Excellent. Another question here. Would you recommend contracts for freelance volunteer writers? So the answer to that is it depends, right? So it depends on what they're writing, number one, and whether you care whether you own that content or not, right? Like, and again, this kind of comes back to the relationship between contracts and copyright, right? Because if there is no contract, then you know that the person that's writing an article or writing a story, they outright own that content, right? And you may not even have any ownership to that, right? If you don't have any involvement in the creative process. So if you're okay with that, awesome. But still, usually it again depends on kind of what you're doing, and what type of relationship you want to have with freelance writers too, because there are other things outside of copyright that you might want to account for. So like if they're getting paid anything, you definitely probably want that critical term in a contract. And like what happens if, you know, depending on the payment, maybe they get paid in terms of like the number of eyeballs that actually view the article. And like what happens if nobody views the article that month? How do they get paid? Are they entitled to get paid? Right? So some of those like critical functions of that relationship in terms of how you want it to work, it can be important to have a contract in place so that everybody's clear about expectations, right? What are my rights, but also like what am I obligated to do here, right? And so having that in a contract is a good idea. Great question. Any other questions?
Like we got all the questions. So, yeah. Oh, we have a question here. Hands up. Can you hear him?
I can't quite hear. You might have to just repeat it.
How about this?
All right. I
Hi.
want to sell like flying toys, remote control airplanes, kites, etc. Like out of my van on the side of the road. Like what? I mean, since it's not like since there's no storefront or anything like that, like if I go to, I don't know, like the beach or something, and I assuming I get like the city licenses, town licenses, is there something I should be thinking of like specific to like kind of like kiosk or like roadside kind of that kind of thing?
That's a great question. And I think, you kind of identified the first thing that came to my mind was, oftentimes in the cities, they'll have like different restrictions on sales like that, right? And so having the appropriate permits from the city could be really important. Um, that's certainly the first thing that comes to mind. Permits and licensing. Um, it's funny because that's more of a traditional form of commerce that you're talking about there, and that's not something I've had to deal with in a while, right? Like a lot of times people that
Okay.
that we talk to are doing a lot of like online e-commerce type business. But yeah, I think that's off the top of my head. I mean, again, I haven't had a chance to really think too hard about it, but that's probably first and foremost the main concern there. There may be areas where you're not allowed to sell certain things, right?
Most areas, yeah.
Yeah.
No, that's great.
Yeah, I didn't know
So,
if there's anything
Cool.
else.
well, thanks.
Sexy.
Well, thank you so much, Erica. And you guys are amazing over there at New Media Rights. We really appreciate all that you do. And this is super informative for everyone here. I wish you could see everyone smiling and happy here. But thank you so much for everything. And what a great presentation.
Yeah, thank you guys for having us.
Thank
It's
you.
always really great to come and talk to the rec. And you guys are always doing some really awesome and innovative things over there. So keep it up.
Thank you so much. Well, have a great night. We look forward to having you back, hopefully in person next time. Or
Yes, in person next time for sure.
awesome. Well, thank you so much again. You guys rock. Thank
Yeah,
you.
thank you guys. Thanks for your attention and your time. Have a good one.
You too. Thanks. And thank you
All
everyone for joining us. Have a great night, everyone. Thank
right.
you.
Bye.
Bye.